On May 29, 2014, a New York County trial judge handed down a decision in a school assault case, which serves as an important reminder about the biggest and perhaps most easily avoidable mistake that can mean the difference between a great case and a case that's likely going to be dismissed in the school negligence context. By now you should be wondering, what can possibly make such a difference that it might prove dispositive as to whether or not a child wins or loses their case? Technology has made the nature of potentially available evidence markedly different over the last number of years. In the school negligence context, this means that the first place you should look to is to find out whether or not the school has any security videotapes showing what actually occurred. Here's the tricky part. You have to move very quickly on this, because schools will often tape over existing videotapes unless the specific demand is made that they preserve the video shortly after the occurrence. Here's why the New York County Trial Court's decision in Rodriguez v. City of New York drives this point home. In that case, the school lost the videotape after a demand had been made for it, and even though there were other ways for the plaintiff to prove their school assault case, the court still sanctioned the defendant and stated as follows, quote, "The video is neither the only nor most critical proof in plaintiff's case in chief, although it may have assisted plaintiff in proving the timing of the occurrence and to some extent the supervision of students during their departure from the school. Therefore, an adverse inference charge to be determined by the trial judge is appropriate here." In other words, even though there were other ways for the plaintiff to prove this case, and the videotape didn't inherently destroy, the loss of the videotape didn't inherently destroy the plaintiff's case, nevertheless the court felt it appropriate to punish the defendant for losing the videotape. Naturally, this is just a brief overview of a much broader topic. If you have any further questions regarding your school assault or school negligence case, please feel free to pick up the phone and give us a call. The number is 516-791-5700. This is Jonathan Cooper, and thank you for listening.